We just recently actually closed out a misdemeanor battery case. A young man and his mother came to my office about a year or so back. He had been charged with battery. It was a guy, I think, owned either a mechanic shop or a tow shop or something. He had, I think it was a young guy, and had put I guess he had opened a condom and put a condom on a door handle. It wasn't, it was fresh out of the package, but when the guy working at the shop, reached for the door and touched it, he didn't know that, and he got upset. So he attacked my client, and then my client, sort of on reflex, just punched out, as the guy was coming at him, and, hit the guy in the face. And so he was charged with battery against this guy for punching him. And so when he came to my office, explained what happened, as is customary, we filed our motions, including discovery motions. And fortunately for us, the business had a security camera of good quality that captured the whole thing. And we were able to establish that the either employee or business owner had crossed about 10 to 15 feet, I think, to attack my client, and that my client had only hit him after he had made contact. So, and this is true in felony and misdemeanor cases, when you've got an affirmative defense, such as self-defense, you really get two bites at the apple. You can do what's called a motion for immunity. And the way the law is structured, Georgia has decided, and our appellate courts have interpreted the self-defense statute to not just give you a means to win at trial, but it also entitles you to not be prosecuted at all. And what that means is, if you allege self-defense through an immunity motion, you get an immunity hearing before trial, before anything else happens. You go in front of the judge and you present your case. At that point, the defendant has the burden to prove, unlike in a normal criminal situation, the defendant has to prove that he was acting in self-defense. But his standard is lowered. So instead of beyond a reasonable doubt, it's the civil standard, more likely than not. And if he wins at that hearing, the case stops and it's over. Now, if he loses at that hearing, that doesn't mean he can't claim self-defense anymore. You still can argue it at trial, and then the jury has to determine beyond a reasonable doubt that you were not acting in self-defense, meaning that the burden then shifts to the prosecution, that they have to prove that you were not acting in self-defense. So in this particular case, we filed a motion for immunity. I spoke with the prosecutor, who I think hadn't seen the video yet, and I said, "Listen, man, you really need to watch this video." He was clearly being attacked while he punched out. Ended up, I guess they finally watched the video, and then I think it got escalated up from an assistant to the Solicitor General herself for the county. Negotiated with her, and she agreed based on the evidence and based on my pending motion to do what's called a dead docket for 6 months. And so long as my client did not have any other infractions, any other criminal offenses during that 6 months, at the end of that 6 months, she would just dismiss the case outright. Of course, take that back to my client. And although we were confident in the evidence in our immunity motion, the fact that they were offering to dismiss the case in its entirety, we had to jump on that rather than take the risk of, whatever could happen with a self-defense claim. And so true to the state, true to their word, dead docketed the case for, I believe it was 6 months. We marked it on our calendar, notified them that the time had passed, that he had been in no trouble, and then they promptly dismissed the case, and my client's record is still clean. So we were pleased with that, he was pleased with that, and it's just another example of, if you know the law and you're on top of getting all of your defenses in timely, you don't even necessarily have to win your motion. As long as you convince the state that you will, you can get great outcomes for your clients.